This is the matter of the guardianship of Garrett Dosch, 99G020357. I'm Judge Linda Marquis. Also joining us is Alexander Falcone. Alexander Falcone was at the last hearing, and I believe is with our Nevada judges and is recording today's hearing. Also joining us is Dan Goodsell. Ms. Cole, is he one of your accounting experts? Is that correct?
Your Honor, no. He filed a report about the Special Needs Trust, and I wasn't sure if the court wanted to hear from him regarding that, so he's here.
Thank you so much. Also, Dara Goldsmith. Ms. Goldsmith, your appearance for the record.
Good morning, Your Honor. Dara Goldsmith, bar number 4270, on behalf of Travis and Melodie Dosch.
Ms. Brickfield, your appearance for the record.
Elizabeth Brickfield, bar number 6236, on behalf. I am the guardian ad litem for Dara Goldsmith.
Thank you so much. Also, Mr. Berchtold.
Good morning, Your Honor. Jim Berchtold, Legal Aid Center of Southern Nevada, bar number 5874, appearing on behalf of Garrett Dosch.
And also Ms. Cole. Ms. Cole.
Good morning. Lorien Cole, bar number 11912, on behalf of the guardian, and Mr. Willick from my office is also present.
Thank you so much. And Ms. Cole, is there someone else from your office on the line?
Good question.
Victoria was the one I didn't know.
Case manager Victoria Javiel is also on the line. I also asked Dr. Consor to be here today. He did a report previously with recommendations, and as I stated earlier, Mr. Goodsell is on the line, and I do believe our accountants are also on the line today.
I think that's right. In addition to Rick Black, Dr. Consor is the only other person. Mr. Black, can you hear us all right?
Yes, you sound fine, Your Honor.
Thank you so much. And Mr. Black, for the record, are you a person of affection in the community, or how would you classify yourself in this case?
In this case, I'm a personal friend of the family, the Dosch family.
Thank you. To the court, counsel, now that Mr. Berchtold, Ms. Brickfield, Ms. Goldsmith, now that supplement has been reviewed by you, and what are the remaining issues in your mind? Mr. Berchtold?
Your Honor, with respect to the accountings, I don't have any issues. I think they're in pretty solid shape, actually.
Okay. Do you have any issues with those payments back to the credit cards? And I think specifically in the supplement, it's stated that those, although there's no proof or receipts that those items were used, and I'm speaking about the food and the personal items were used for Mr. Dosch. Do you have any concerns about that?
Honestly, no, Your Honor. I mean, when I look at the overall, first, it's hard to go back 2 years and analyze. If somebody asked me to go back 2 years ago and look at my credit card statements and tell you what they were, I wouldn't be able to do it. So I realized that it's hard to go back 2 years and try to reconstruct all this. So what I did was I really just had to look at the overall amount that was being spent for Garrett, for his care, considering that he's living independently, he's got a full-time caregiver, and the expenses in total were around $45,000, and I just can't see that as extravagant by any stretch of the imagination. So I have no doubt that at least the majority or some portion of those expenses were for Garrett's benefit.
Right. Mr. Berchtold, do you have concerns, or would you request going forward that those expenses be further itemized and that receipts be retained?
Well, I think the statute requires that receipts be retained, and I would love to have them a little bit more detailed. And I'm hoping that after all of the effort, given all the effort that is put into this accounting, that going forward there is some better system in place to keep track of everything going forward. So yes, I would love more information, always. That being said, I really can't justify going back to 2 years and arguing over what happened 2 years ago at this point.
Thank you, Mr. Berchtold. Ms. Brickfield?
Thank you, Your Honor. I have a a difference of opinion with Mr. Berchtold on this. This is the third set of accountings that we've seen from Ms. Dosch for this period that ended on July 25th, 2019. And the accountings don't really differ among themselves, and what's lacking from these accountings, whether it's Mr. Biederman's iteration, Mr. Yu's iteration, or now the latest iteration, is any evidence to substantiate the expenditures. I find that if you recall, Judge Ochoa specifically ordered Ms. Dosch to keep receipts of everything from December of 2018 going forward. But yet, the receipts that the accounting firm relies on are simply the credit card statements and the bank statements. There's no underlying receipts, and as the accounting office pointed out, they are not aware of what was purchased, what these items were, and the accounting firm has agreed as well that they don't know whether because of the lack of receipts that were court ordered to retain in addition to the statute requiring them, it's difficult to know what was spent for what. The main goal of this latest accounting iteration has been to take some charges that were paid by Garrett and translate them into an unapproved guardianship fee. In addition to that, Your Honor, not having receipts, not knowing what's going on, Garrett is paying for things that are clearly not his responsibility, like vehicle charges, like insurance, like utilities. If I agree with Mr. Berchtold on one thing, that we cannot spend, it's not in Garrett's best interest to spend more time on these retroactive accountings. However, particularly because the accounting for the next period that ended on July 25th, 2020 is now due and more than due. So we're in a situation, Your Honor, where we don't know whether this was done for Garrett's benefit, where the charges may not appear unreasonable, where we're now looking at $24,000 of accounting fees in an accounting for an estate that only has about $300,000 in it. And we don't know much more than we knew 2 years ago when Mr. Biederman did his accounting, that he separated into categories. That's just a long way of saying that I don't think this is advanced. I don't think we have any evidence. And the other thing I don't think we have any evidence for are Ms. Dosch's claims of payments that she says on the accounting she paid for Garrett's benefit. There is no evidence supporting that. The reliance that the accountants have are the American Express statements that simply say Lorien Dosch payment. It's not a source of the payment. It's not a documentation of payment. It simply says this is the person who made the payment to Amex. And on some of those Amex bills, for example, it'll say 2 payments by Lorien Dosch, but she's only claiming 1, which is why I think it identifies the maker of the payment, not the source of the payment. So that is an issue, and that is a concern for me as to what benefit Garrett has gotten from this third iteration of an accounting. Thank you for hearing me.
Ms. Goldsmith.
Thank you, Your Honor. I have many of the same concerns as Ms. Brickfield does. We go back to a time when there was the accounting that was filed going back, one more iteration was filed by the Barney firm along with a budget and an inventory. And we had actually it was an inventory and a budget. It wasn't an accounting. We had objections to those. Those have items still not been approved. What we did at that time, going back to October, we had been in October of 2018 and in November of 2018, we finally came to a stipulation, and it was stipulated that while these things were pending, that Ms. Dosch would be receiving this monthly distribution for the benefits. And it was specifically ordered by Judge Ochoa that she was to keep all receipts. I think this is just merely evidence again. Ms. Ms. Dosch fails to follow the law. She fails to follow the directives of this court. She does what she wants. We don't know whether when she's doing these Walmart purchases, whether she's going back and getting cash back. We don't know what she's doing. We don't know. We know it's the same. It's just repackaged a different way. You know, initially we're given hamburger and then we get sloppy joes. It's the same stuff. It's just changed. And it's unfortunate that Garrett has incurred additional expenses with regard to each of these accountings to be prepared. And we did get some additional information in this last accounting, but it's limited. She fails to keep the receipts. The statutes require it. She was expressly directed by Judge Ochoa, who made sure she understood that in 2018, and that was part of the reason why we all agreed to that monthly distribution. So my concern is that she just continues to disregard whomever the judge is, whatever the directive is by the court, and fails to follow the law. And so I still continue to have these problems with the accounting. I understand that the numbers match up. We're not, you know, and I believe, and the accountants have done that and have matched up the numbers and provided explanations, but we still don't have the information that she's statutorily required to keep. Thank you.
Thank you, Ms. Goldsmith. Is there anyone else on the line that has an objection to the first, second, or third accounting? Ms. Cole, is there any other testimony today that you would like to elicit from anyone on the line regarding the accountings?
I certainly can respond with some argument myself. I didn't hear.
Sure. Go ahead.
Okay. I'm just going to address some of the comments that were made in the order they were made. First of all, I appreciate Mr. Berchtold for pointing out the fact that Ms. Dosch has kept within or below the amount that Garrett receives and even the budget that was suggested for her. I believe that the average expenditures were even under $4,000 a month. So the fact that we're spending so much money arguing about this for years is pretty unreasonable considering the amounts in question.
Ms. Cole, would we be arguing about it had the accountings been filed on time with all the documents that were ordered that are required by the statute and by Judge Ochoa to be retained? Would we be having this argument?
Well, I guess I do quibble with the fact that she does this argument that she doesn't have receipts. So first, I think that we've already gone through the fact that her previous attorneys did not do a good enough job for her. And they already got stiffed on all their fees. We had a hearing on how they weren't doing their job to provide the proper documents. And the result was they didn't do anything for the protected person or very little, so they're not entitled for fees from the guardianship estate. So here we are. All those fees so far were borne by Ms. Dosch to try to get this done correctly. So now she comes to court. She is tasked with getting new attorneys who have to get caught up on the case. Now we have to start over from 3 years ago and there weren't multiple accountings done. There was one done by Biederman's office for the first. There was one done by Mr. Hughes's office for the second. And I want to put on the record as well that no one in this phone call or Blue Jeans call objected to the second accounting. The only objection on record in this case is for the first accounting. So for the second accounting, I'd ask the court to simply approve it. But the receipts that were provided when we did, and I went back and looked at what was done by the first and second accountings, and they were deficient. They didn't have the appropriate worksheets. They didn't have all the bank statements and credit card statements attached. But the court specifically ruled at the last hearing on Thursday that bank statements and credit card statements are considered receipts under the statute. And I was ordered to give those documents to Ms. Goldsmith. So every single transaction that we attached to the accountings had credit card statements and bank statements that were itemized to explain. We also produced a number of paper receipts that were photocopied. So the fact that we did produce all the bank statements, all the credit card statements, and again, American Express itemizes every single transaction, and we also submitted a number of photographed receipts, was not acknowledged by anyone in their arguments, anyone that objected today. I find, just in a general manner, it very disappointing that it feels like there's a lot of animosity towards my client when she's Mr. Dosch's mother. She's cared for him his entire life. She was the one who brought the concern to the court that someone was stealing from his trust account. In fact, someone was stealing from his trust account. Now she is keeping the amount that's received far under budget. And I explained, even the accountants explained, when we went through each of the sections of objections. For example, yes, she has Garrett pay for certain utilities, but she also pays 100% for other utilities. They live in the same residence. They live very modestly. And I asked Dr. Consora, for example, to be here today because he explained even further in his supplement, Garrett lives on this ranch. He lives a modest lifestyle. He does, in a sense, a lot of things that would be considered occupational therapy. He works on cars out there, engines. He attends all the town hall meetings. He enjoys his life out there. He gets his speech therapy. And every time we turn around, there's a continued narrative to try to change what Mrs. Dosch is doing, that Garrett is
Ms. Cole, I want to direct you to the accountings issue.
Okay. Yes. So back to the accounting. So in the subject of the receipts, I think I covered that. Yes, there are plenty of receipts attached, and we attached all of the bank statements. Again, I did not receive an objection to the second accounting, and none of the attorneys previously got their fees. So those were not approved accountings, and they weren't even approved for payment on those accountings. Some of the more specific objections, again, vehicle charges, those were all explained by the accountants. I didn't get any argument today that addressed the explanations to those statements. It's simply a blanket objection because I don't like maybe what you're doing in general. It's not, okay, the fact that he's driven around and he might have bought parts for some of the things he works on the ranch wasn't good enough because. So we've already addressed these objections through the accountant's supplemental filing that we made. Again, just kind of going through the list. The third accounting, that's done. I have Ms. Dosch simply needs to review and sign it. It was a lot less work than the first two. The first was the most work because I had to go through a narrative of explaining all of these objections to things that were really irrelevant or minimal, but I had to go through and explain them so that they didn't come up again and again and again, like Ms. Dosch's truck and this trailer that they keep bringing up. So that took the longest. Plus I had to we all had to format the forms properly. The second accounting was less, but the third is going to be even less time. However, I've talked to the accountants about this. If they have to itemize every single expenditure and make worksheets and put it in their system, and I understand and I appreciate Mr. Berchthold's comment that more information is better, but the accountants, the way they're required to produce these worksheets, they have to take every single itemized expenditure and they have to enter it into their system separately. So that's why we have a $20,000 accountant bill. If Ms. Dosch, if we looked at the accountings and the expenditures, and again, she's even under what she was in the first two accountings with her spending in the third accounting when the court sees it, which I will get, again, I'll get filed as soon as she signs it. I believe she was at $3,900 a month average spending. If she's just simply allowed, say, $4,500 a month to spend on Garrett and to spend for her accounting fees like we had proposed in our budget, then we can simply produce the reconciled sheet with the bank statements and credit card statements separately produced and not have to have every single expenditure entered into Excel and populated by the accountants. That would save hours and hours of time for the accountants. So I was going to say today, if we can discuss that as being an option in the future, then that will minimize Garrett's exposure to fees in the future. And we could probably produce these reports very minimal cost, or another attorney or another accountant could, based on the fact we've got 3 years in and she is being very modest with the spending. So again, my comment here that I wrote down when the argument was going on was the expense of the accounting. It has to do with that level of detail that is being required by everybody so far.
Let me be clear. Let me be clear that the level of detail that's being required by me is pursuant to NRS 159.179. It is not my idea. It is not Ms. Goldsmith or Ms. Brickfield or Mr. Berchtold's idea, nor are we anyone arguing in this case that Ms. Dosch should be held to some higher standard or that an additional level of detail is required by her for some nefarious reason.
No, I understand, and I'm not suggesting.
This is the idea of the legislature. This is the rule. This is the statutory requirement. Receipts are required. I understand that it might be complicated. However, the vast majority of guardians are able to do this on their own without an accountant. The nature of this estate is extraordinarily simple. This has been the choice to hire an accountant and try to recreate these accountings from a box of documents. That was, the guardian's choice. The guardian could have done this. We keep talking about 3 years. This goes back to 1999. When she was guardian of the estate for both Travis and Garrett, and she didn't supply accountings for 3 years. And then there was a stipend order to remove her as guardian of the estate. And in 2005, that stipend order indicated that although Mr. Gottesman, the accountant from Pahrump, was still required under subsection G of that stipend order to provide annual accounting. She never did that. And I understand that, quite unfortunately, there was extraordinary wrongdoing over those 12 years. And that, now here we are, and she's back to being guardian of the estate. And we're back really to the situation that existed in 1999, where we don't have 3 years worth of accounting. So she has been at this for some decades, right? She's been guardian of the estate and a guardian for a very long time. These rules really aren't new to her. The annual accountings were still required.
I can't go back unless the court tasks me again with the job of going back to 1999. The scope of our engagement was to make sure we got the first, second, and third accountings beginning in 2017. We attached all the receipts in that, I say, the bank statements, the credit card statements, and paper receipts. I'm not suggesting that in the future she file accountings without complying with the statute, Your Honor. She will produce all of the receipts with them. It's having to itemize every single $10 purchase. Get an objection, for example, that she went to Walmart to buy food, and how do we know if it went for her and Garrett or just Garrett? How do we not know it went for just Garrett?
Well, if we had the receipt from Walmart instead of just the credit card statement, we would know.
It doesn't matter. It's food. Let's say it's food. How do we know that she ate it and he didn't?
So these are issues that ordinarily come up quite a bit in guardianship cases, and we hear
especially when it's a family guardianship and they all live together.
And we understand that. We take a look at the food that was purchased, the frequency that it's purchased.
Yeah, right. So my client, Ms. Dosch, now when she goes to a restaurant, she orders for Garrett on his credit card and she orders for her on her credit card. That's, which is fine. That's what she's supposed to be doing. Does she now need to submit all her credit cards to show that? These are issues. We could go to court and it doesn't matter what she submits. There would be objections based on things of that nature. So the reason why I bring this up is I'm not saying that we don't give receipts. I absolutely understand that's the requirement of the legislature. I'm saying we provide all the receipts in disclosures the way that I have. My suggestion, though, was to have her allotted a certain amount of money to be able to spend on Garrett, to have some accounting fees for herself, which, again, no one objected to that. Even the guardian ad litem didn't object to that. she's entitled to some compensation for everything she does as well. My suggestion was make it $4,500, have her still reconcile the amount spent to comply with the statute, have her submit all her receipts as required, but not, and when you say she didn't need an accountant, I was told, in fact, one of the very first hearings we came to, that finally we got a CPA on this case so we can get proper accountings. So the suggestion was that I needed an actual accountant. The bookkeeper was not sufficient. That was basically rejected. I needed someone that had some experience to organize this information properly for the parties in this case in the court. And I was under a landslide of objections on everything Ms. Dosch did or had done at that point. And I asked the court to give a little bit of deference in the fact that all the things I addressed in my first accounting and argument have never been brought up again. These are things that have been objected to for the last 2 years. Things like the title to her double wide trailer, things like that. Now we don't hear any objections to that because everyone realizes that was not worth objecting to. But I had to go through the work to provide pictures of it, to provide an explanation. I am simply trying to get this case to where no one's having to work very much and no one's having to take money out of the estate of the protected person. Very little, so that we can move on and Garrett can keep his money. My client doesn't want Garrett's money. She's trying to take care of him and comply with the statute and everyone's objections. And why are there so many heated objections? Because that's another reason why I had Mr. Goodsell here today, because all of this time there was so much conversation and advocacy on the Special Needs Trust. So I had Mr. Goodsell do a report on it. And it turns out that it's not even what he would recommend at all for someone who has a family member alive. That's putting it in the hands of a third party or even an institution who would cost money and take more money out of the estate for the protected person.
I'd like to focus first on the 3 accountings. Any arguments or requests for issues in the future, I'll consider, but I would like to first take care of these 3 accountings. Ms. Cole, under the statute, in the absence of receipts or vouchers, you're allowed to elicit any testimony. Would you like to do that today or no?
Well, I have the receipts in the form of the statements and the itemized credit cards, which, as I said last week, the court defined under the statute as a receipt. So unless there's a specific objection to any of the attachments or productions that I have with all the receipts and the copies of paper receipts, I would not know how to address that question. So if any of the parties that are objecting want to specifically point out a receipt that is not, that they believe is insufficient, I have the accountant here to respond.
So NRS 159-179 allows you to elicit testimony from a witness regarding the receipts or vouchers. I'm giving you that opportunity now. The statute doesn't require an objection. I'm just giving you the opportunity. So if you would like to take advantage of that opportunity, I'll allow you to do that in reference to the accounting. If you don't want to, you can do that as well. It's up to you.
Sure. I mean, I have the accountant Kirsten on the Blue Jeans call. Kirsten, can you hear me? Do you mind unmuting yourself?
Yes.
Is there anything, and I don't mean to be so general, but just let's focus on the first accounting. In the first accounting, were there any?
Hold on. Ms. Lambert, will you raise your right hand to be sworn?
I'm sorry.
Yes.
Thank you.
Do you solemnly swear that the testimony you are about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name for the record.
Kirsten Lambrecht.
And spell your last name.
Lambrecht.
Why are you here today?
Our firm and myself prepared the attached spreadsheets that reconcile the cash and assets of the estate during the first. We did all three. I think 2 are submitted, and the third will be submitted shortly.
And when you say your firm, what firm do you work for?
I'm with Reuben Brown.
What does Reuben Brown do?
Reuben Brown is a public accounting firm with offices in several cities.
And what are your qualifications?
I'm a tax manager there. I have over 20 years experience working, preparing tax returns. I specialize in gift and estate and trust issues. I have prepared several trust accounting reports for, I haven't done one for a guardian, but have done them. They're very similar to the trust accounting that is required as well. So,
Education certifications that you hold?
I'm a CPA. I graduated from UNR several years ago with a marketing degree, took the CPA exam, and have been licensed here in Nevada for several years. I'm not sure when I actually got it.
What did you do in this case?
I oversaw and prepared the spreadsheets to some degree, reviewed. I had people assist me in the office, but for the first accounting, for sure, I did the entire accounting.
Have the first accounting in front of you.
Yes.
And when you say you prepared them, are you talking about the worksheets that are attached to the first accounting?
Yes.
Okay.
I'm sorry. Yes, I did the exhibits.
No problem. Turning to the exhibits, I'm looking at Exhibit B to the first accounting. Tell me what the numbers were next to the figures in your accounting on Worksheet A.
So I'm assuming it's either the account number or the bait stamp that you're talking about. The
bait
documents were provided to us. The bait stamp, those coincide to the statements, either the bank statement or the loan or the American Express card statement.
So every time you put a figure in your accounting, you reference the statement that it came from?
Yes.
Okay, so moving to Exhibit D, please, at Worksheet B.
Yes.
Are there any entries that do not have a bait stamp number?
We're able to, I do not believe so. We were able to, they coincide again to the statement.
Okay, and then moving to Exhibit E. What does this exhibit represent?
That is a list of all of the expenses, all the cash outflows that do not impact the net asset value. So you'll see interest expense, but you won't see any sort of payment on the principal of any of the debt.
Okay, so sorry.
Go ahead.
Starting with the first entry, explain how you organized your the expenditures here, starting with that first line. Starts with groceries.
So the first charge onto the American Express card was to Walmart. It was based on the date, and it had the corresponding amount.
Whose card was it?
So this was a difficult year to get through. When it first started, July 10th of 17, all of the charges were on Rain's credit card. Starting in March of 2018, Rain had a separate card for Garrett. For the rest of the accounting, there were 2 charges. She was making payments on her share. It's kind of a progression. This first accounting was a little blurred the second and third, there was a very clean line between what was being charged on Garrett's account with Garrett's card or Rain's card.
Are you aware that at the time that this accounting started, Rain was just the temporary guardian? She was not the permanent guardian yet?
I wasn't aware, but I knew she started as his guardian of his person. So, and she was assigned, she received the guardianship of the estate during this accounting.
Right. And isn't it true that the beginning asset value of her first day as a temporary guardian was a negative number?
Yes.
Okay. And why
Yes,
was it a negative number when Rain first started her?
She had more debt than she had cash.
And where was all of Garrett's cash at that point?
Garrett's cash was in the American First National Bank.
And who had access to that account?
I believe Rain and Garrett. It might have just been Garrett.
Right. But when you say there's a negative number, wasn't there other cash that came in during the accounting period?
Yes, there was cash that came in during the accounting period. You'll see on worksheet Exhibit D, which is worksheet B, you'll see amounts coming in during that time period from the former guardian of the estate. They opened up two new Wells Fargo accounts. One of those accounts is blocked, and the other is where money is transferred monthly. I'm sorry, I missed it if you said something, Lorien.
No, I was looking on worksheet B. So when does the first distribution of income start in the first accounting period to Ms. Dosch?
Let me get the entire worksheet B. I'm sorry.
And I'm on Exhibit D.
Sorry for the delay. I had
Well, this is the one that was missing a page, so I apologize for the.
Yeah, let me pull that up.
And I was actually going to ask you a question with the first page missing also. So let me know when you get there. It's in our supplement that we filed with that first page attached.
Right. I have to go to a different source.
Ms. Cole, while she's looking for that, I would remind you that the statute talks about testimony or anticipates testimony about expenses being faith. I would direct your attention.
What? You cut out. I'm sorry.
I'm sorry. So the statute contemplates that if a receipt is missing, that you may get testimony about whether or not that expense was paid in good faith and is a valid charge against the estate. So I would direct your attention to that line of questioning.
All right, I have it open. So the prior guardian was putting $3,000 approximately into the account for 3 months during that time.
Right.
For the monthly charge. Then there was a break, and the funds from the guardian started being transferred into Wells Fargo in November. November 14th was the first date.
Okay. And the second account, and you did every accounting so far by referencing the document that you relied upon to get that number. By putting the date stamps next to your accountings, correct?
Correct.
Okay.
So there were some things in there. I'm sorry. I was going to say, with regard to some of those charges, there was insurance, for example, that was charged and was over the $250 limit. Those were done online, and assuming I can't tell if it was just for Garrett. I don't know if I would be able to tell with the receipt or not. But it is a monthly charge that is to him. So that there aren't very many charges over $250. You can see the frequency of the visits. It's almost as if, that's what they do a couple times a week.
And with respect
And then
to
going forward, there's definitely two different charges where they're ordering two. You can see that they are ordering separately and paying separately.
I'm I'm going to pass this witness. Anyone else who wants to ask her anything?
Mr. Berchtold, do you have any questions for her?
No, Your Honor, I have no questions for the accountant.
Thank you, Ms. Goldsmith.
Your Honor, I have a few questions for her.
Go ahead.
Ms. Lambrecht, you testified that, is it correct that you testified this is your first guardianship accounting?
My first guardianship accounting, but that they are nearly identical to the trust accounting reports,
All right. So can you
which
describe
I've done
for,
several.
can you describe for me the differences between NRS 159-179's requirements for an accounting and that of 165-1207 for a trust?
I don't, no difference comes to mind with the exception of the receipts.
Is it sufficient under 165-1207 to provide the fiduciary tax return and be in compliance with the trust accounting statutes?
No?
Would it surprise you if I told you that 165-1207 would allow that for a person who's entitled to receive income?
Is that a relatively new
How is this relevant?
statute?
I'll allow
I
it.
believe this is relevant to show that Ms. Lambert is probably a very experienced trust accounting attorney, but guardianship is a different animal, and compliance with 159-179 is mandatory, and it's different. And although, so I think that this is to show that she's probably outstanding, exceptional on a 706, a 1041. But with regard to an accounting in a guardianship, it's a different animal.
I'll allow it. Continue, Ms.
How would you say it's different? I mean, I'm looking at this, and it's you start with your cash and the assets that you have. You reconcile your inflows and your outflows. You reconcile changes in net assets, and then you provide that information to the court.
The recapitulations are exceptionally similar, but the backup that's required or the backup then can be requested. And in this event, the backup that was ordered by the court and that's required by the statute is not what you base the accounting upon. You based it upon basically more of a compilation report. You based it upon not receipts. You based it upon items that don't qualify as receipts in that they are bank statements without the underlying backup, as well as credit card billing statements. And although it's not to say that, two people dined and only one person was paid for, we don't have the backup receipts at Walmart. We can't say that women's undergarments weren't purchased or, whatever. Women's vitamins versus men's vitamins. We don't know what was purchased. And if we had the receipts, which is what is supposed to be maintained, not necessarily by the accountant, but maintained by the guardian, and the guardian is supposed to give you maybe spreadsheets with that, but have these receipts available for people to review. I don't quibble that the numbers don't add up, That is not the issue. The issue is the lack of the backup. And that backup was requested and that backup was specifically ordered. And I don't believe that you have personal knowledge that you can say in testimony what was purchased in good faith. You have no idea what was purchased in good faith. You can look at the statement, but you don't have that personal knowledge. Is that correct?
I do not have knowledge regarding the detail of it. The only thing I do have knowledge of is tracing the two separate charges each day, because those two charges are included in the American Express account. But right, there could have been something included in the other. I have looked at Walmart charges though, and it's very difficult to tell what specifically is being purchased. You see abbreviations, item numbers, which don't mean anything, so naturally those are there. Again, it's one of those, you can see the pattern of spending, staying within budget, and the two separate charges for dining out.
And I appreciate that. And I see that you see that, but you don't have the personal knowledge of whether, of what the underlying transaction was.
No.
And I believe that your lacking of the underlying knowledge of that is not in compliance with 159, 179, 5.
Because you'd have to gather this from the receipts, is what you're saying. She would have to provide every single $9 charge or $6 receipt.
Correct, just like every guardian does.
Do they submit? I thought it was just $250 that they had to submit the receipt.
They
for.
can be requested to submit all. They have to retain them, and they can be requested. And in this case, she was ordered. And it's a little bit, Your Honor, some people are laughing, and so it's a little bit difficult to be speaking.
Let me
while people
comment.
are
Mr.
laughing.
Black, I see that you're laughing during the questioning. Is there something that you wanted to say?
Yes, Your Honor, if I'm asked to address the court, I have looked over hundreds of accountings that have been approved by this court, going back as far as 1999, to use your earlier statement, which isn't the topic of today. But I can go to a record that was approved that had no receipts, and I can show hundreds of accountings, 1st, 2nd, 3rd, 4th, 10th, 15th, that never had receipts and were never objected to or never unapproved by the court. So I'm humored because Ms. Goldsmith is laying claim to untrue statements. There are often, matter of fact, the majority of all accountings approved by this court did not include receipts, ever.
Pursuant to the statute, the receipts have to be produced upon request. So, Mr. Black, I appreciate your statement and ask you just not to laugh during the questioning. It can be a little bit distracting. And I understand that you find it humorous, or I understand your statement that you find it humorous. It's a serious issue to me, and I just would like to be able to
It is
focus
to me
on
as well, Your
context.
Honor, and I will refrain from smiling or laughing. My apologies to the court.
Thank you. Ms. Goldsmith.
And Your Honor, I acknowledge that many accountings, no one asked to have these produced, but these were asked to be produced. These were ordered to be produced by Judge Ochoa. And they were ordered to be retained, actually, not to be produced. They were ordered to be retained by Judge Ochoa. And they weren't. I mean, some were. There are some expenses that they have a few receipts. But I would submit to you that I don't believe you have enough information based upon the objection for the lack of receipts that this witness has the personal knowledge in good faith that you can rely upon in order to approve that portion of the accounting.
Okay. Are we skipping cross-examination and going to argument, or are we doing cross-examination?
Ms. Brickfield, do you have any questions for this witness?
Thank you, Your Honor. I do.
Go ahead.
Ms. Lambreth, I am looking at your, well, first of all, have you seen the objection I filed to the petition to approve the retroactive guardianship and to the accountings? Have you seen that?
I don't believe so.
Okay.
I might have been, I don't know that I might have been provided with them. We were
Sure.
not engaged to, but those.
Sure, I understand that. So, first of all, I went through your first amended accounting, and I set out a series of items, all of which had a Bates number that began with A, F, B, and B, and then had a Bates number, and were characterized by, in the accounting, as groceries, hygiene, household supplies. But when I looked at the document you relied on, for example, I will take an entry from your accounting on 7/18 of 2017. That comes from AFNB. That's the Bates number prefix. Does that, am I
I'm
correct
sorry,
that
just a
that's,
minute.
sure, take your time.
I'm sorry, I'm sorry, Ms. Brickfield. It was, I'm sorry, what date? And
7/18 of 17.
7/18 of 17. Okay.
there's a charge for $60. Do you
Yes.
see that? That
do.
you've characterized as groceries, hygiene, household supplies? You see
Yes.
that?
Okay.
So
There
let
was
me ask
cash
my,
taken
I
out.
didn't, Miss Lambert, I didn't answer. I didn't get to my
Okay, I'm
question, so please don't anticipate it. So when I looked at your supporting documentation, it refers to an ATM withdrawal of $60. That your testimony? Right.
Yes.
How did you determine what that was spent for that you called it groceries, hygiene, household supplies? What evidence did you have?
It was a cash withdrawal, discussions with Rain about what they would use cash for. It is an estimate. However, there are stores within the area that don't accept credit cards, or it may not be convenient if they went to a mini mart and got a soda, for example. There is a relatively small amount of cash that is occasionally taken out and spent for those items.
So in your first accounting from 7/18/17 through 7/16 of 18, I counted up 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 15 or 16 of them, and they were all characterized as groceries, hygiene, household supplies. So it's fair to say that was an assumption on your part as to what the funds were spent for?
It was an assumption based based on
Okay.
Rain's
Right. Thank you.
description of transactions.
Okay. In regard to your gross, and would you say that was fair for all of the items that are characterized, that were cash withdrawals, that are characterized as groceries, hygiene, household supplies in the second accounting? You looked to
Yes.
see if there was yes? Okay, thank you. With regard to the American Express payments that you characterized as being guardianship fees, I think there were several in the first accounting. If you need me to find a specific one, I will.
I think there was only one,
Okay.
but there was one asked about.
I think there was one for like $5,628 or something.
July 21st, 2017.
Yes. Thank you, Your Honor. How did you determine that that was to be characterized as a guardianship fee rather than an Amex payment?
It was a payment on an Amex card that is not included in Garrett's estate. It's a card that was used that the guardian is responsible for.
And so you decided to recharacterize it as a guardianship fee. Was that your decision?
What else would it be if it's a payment on behalf of the guardian?
So that was why you characterized those as guardianship fees after the fact. Right.
After the fact?
After the fact. You did a retroactive accounting and you characterized it as a guardianship fee rather than an Amex payment by Garrett.
It wasn't a payment on principal, so it would never show up. It was a payment on an account that is not included in Garrett's estate. So it's a liability that is not Garrett's.
Okay. I'm looked at the Amex payments, and I noticed on your gross income, you say that there are payments for, I'm on first accounting. So let's look, for example, on a payment on 10/17/2017, and I'm taking this from the supplemental exhibits to the first accounting.
I see
And
it.
so you have a payment on account by the guardian, 10/17/2017. And then you say that's Amex account 8900, and then you refer to it as Dosch 610. And I believe that's an Amex statement. So how did you determine, by looking at the Amex statements that simply lists payments, what the source of the funds to make that payment were?
I know that the source of the funds were not any of the bank accounts that are listed on the accounting as being part of the estate. So I know it didn't come from either the Wells Fargo account or the American First.
And what documentation did Mrs. Dosch or her counsel provide you to show you that, in fact, she had paid it?
I know that Garrett didn't pay it.
And you're basing that on?
It came from, because I have all of his bank statements, so I know that it didn't come from one of his accounts.
Okay, right. On your, and so you're concluding, for example, that if a withdrawal of cash was taken from one of Garrett's accounts that you characterize as groceries, household expenses, or whatever, that those funds were not used to make any of these payments that you are saying were paid.
They're not significant enough.
I see.
I believe you
What would-
provided the total.
Why would you say that they were not significant enough?
They weren't, the amount is roughly $1,000 over the entire accounting period. A lot of the withdrawals were checks. Some of them were checks or counter withdrawals that were signed by Garrett. There was over $4,000 worth of payments that came from an outside account, and there was not anywhere close to $4,000 being taken out in cash from Garrett's accounts.
Are you saying that Garrett had the capacity to sign a check or make a withdrawal?
I would see their signature there.
But I'm asked you a different question. I asked you, is it your statement?
Oh, his capacity? I
His
don't.
capacity
I
to
can't
do that.
opine to that.
Right.
I can't opine. I don't know what his capacity is, and I'm sure Rain was standing next to him at the time.
Ms. Lambert, did your firm prepared the inventories for each of these two accountings you did? Is that correct?
There was a single inventory, the beginning inventory, and then after the second accounting, it is the ending balances on worksheet. Okay.
What efforts did your firm take to independently verify what assets were owned by Garrett Dosch?
As far as the cash account and the credit card?
No, as far as the assets that are owned by him.
It was provided by, they were provided by Rain. The bank account is obviously, it was included in the other accountings done previously. As far as other assets, we relied on whether or not Rain had any. Lorien addressed each of the issues in her filing and tracked the other assets in question.
So you have no independent knowledge of them?
No.
Okay.
I've seen nothing to support any other assets other than the cash account.
The items that you testified earlier, for example, when we talked about that large American Express payment, that was not from Garrett's, not on an account that Garrett had, and so therefore it must have been compensation to the guardian. That's the way you characterize certain things as guardianship fees. How did you make the determination that they would be guardianship fees rather than a debt owed by Mrs. Dosch to Garrett?
They were payment on account owed to Rain, because she's making payments on that credit card that is Garrett's. Oh, I'm sorry. No, it was one of his. It could have been classified as either one, but she hasn't been paid any guardian fees. I know the court hasn't entitled to it. We could have done it as a receivable where she had to pay it back. And offset it with any sort of amounts that she put into the estate. So we could have done that. And that would have, but I don't think it would be appropriate necessarily, unless the court were to say that is a liability and she needs to pay it back. If they don't approve any sort of guardianship fees, that would be the option.
And this is your first guardianship matter. You testified earlier. So what knowledge do you have of what an ordinary fee is for a guardian?
I discussed it with Rick Black, who has some experience on that. We looked at what the hourly charge might have been given and the type of activities that she was doing for Garrett. It was also included in the budget, which has not been approved yet, I don't believe, but that is one of the issues in question. What would be appropriate? She drives him everywhere. She does his laundry. She takes care of him. She's with him all of the time. There are very few charges to tutors or anything like that. So she is putting a significant amount of time into caring for Garrett.
And okay,
so it certainly seems reasonable and well below any sort of minimum wage.
So that's just a conclusion you're making, confusing the role of a guardian and a caregiver?
What is your question? I'm sorry.
Could you be confusing the role of a guardian versus the role of who is a fiduciary versus the role of a caregiver?
Both of those items, I called them guardian fees. Both of those items are detailed and split out in the proposed budgets. Absent any, they were paid by the Ms. Dosch serves both of those functions, so we would have to decide how we would allocate them to her based on the role that she's playing. They're not separated in this accounting, no.
All right. If Ms. Dosch is acting as a caregiver, if she's being compensated regardless of either, if she's being compensated for those services, is there now an exposure for Garrett's estate for the certain portions of taxings that were not withheld, not paid on that behalf? Does he now have an exposure for that?
She would be classified. She wouldn't have to withhold unless she was an employee of Garrett's.
Why would she not be an employee if she's doing a regular, normal function repetitively on a certain time period over and over? Why wouldn't that make her an employee?
Depends on control and whether or not, and their arrangement between each other, and whether or not she's an employee and whether or not he can control what she does.
But Garrett doesn't have the capacity to enter a contract, so it would be really how Ms. Dosch is characterizing it. Not more accurate?
It would be.
Right. Right.
And she's considering herself an independent contractor.
Right. So I just want to make sure I understand your testimony. You relied on American Express statements, you relied on bank statements, and you relied on the testimony of Rain and the advice of counsel. Is that correct?
Yes.
Okay. You did not see underlying receipts for most of the items on the 2017 and 2018 accounting. I read your report correctly, right?
We were provided with several receipts. We sorted them and found the ones that were over $250. I believe there are other receipts out there that have been provided.
So I was provided...
But we haven't matched every single charge with every single receipt, since the bank statement is more reliable as to the amount.
I see, as to the amount. And the Amex statement maybe tell you who the vendor was, but it certainly doesn't tell you anything about what was purchased. Isn't that correct?
That's correct.
Okay. All right. So I don't have any further questions. Thank you, Your Honor.
Thank you. Ms. Cole, anything else? Mr. Berchtold, did you have anything? Sorry.
No, Your Honor. Thank you.
Ms. Cole?
No,
May I have one follow-up question if Ms. Cole's done to Ms. Brickfield? I can go whenever. Ms. Lambert, are you familiar with NRS 159.305?
Not.
in the accounting?
I can't recall the numbers. I'm not an attorney. I'm sure I've read them, but I
That's
can't
fine.
tell you exactly which one it is.
Would you say that with regard to the $5,000 that you were testifying from July 21st of 2017, that would have been monies that Ms. Dosch, as the guardian, took for her own personal purposes? Would that be how you would characterize just what that transaction was? It wasn't for Garrett.
I think
it was
based on the descriptions, it would be. It was for payment of attorney's fees is what was charged to that card. And those attorney's fees have not been approved by the court.
right. And what that statute talks about is when a person uses for their own benefit the assets of the protected person, that they can be required to return that money. So is it your testimony that if those fees aren't approved, that she would have a debt subject to repayment to or offset?
If the guardian fees were not approved, then she would need to pay them back.
All right. No further questions.
Ms. Cole?
So as far as I understand your testimony, Kirsten, Ms. Dosch was not compensated in any way as guardian or caregiver in the first or second accounting periods.
Beyond those payments on her on the credit card, which again was used for payment of attorney's fees.
Mm-hmm. And again, what your research revealed is typically guardians are compensated for their services.
Yes.
I'm no further questions for Ms. Lambert. I would like to call my client.
Counsel, your appearances for the record.
The court has a few comments before we begin.
We are on the record in the matter, case D-505.
You guys either agree or I order.
I don't hear anyone saying she can't order a change of custody if she follows the right procedure.
There must be an evaluation of the disclosures.
You're going to convince me to hold your client in contempt.
Raise your right hands, face the court clerk to be sworn.
You raise your right hand to be sworn.
You do solemnly swear that the testimony you are about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Good morning. Could you please state your name for the record?
Edith Lorien Dosch, and I go by the nickname of Rain.
Okay. What is your relation, Rain, to the protected person?
I'm his mother and his guardian.
How long have you been the guardian over Garrett's person?
Off and on since 1999.
Okay. How long have you been taking care of Garrett?
42 years.
Okay. And he's how old?
42.
Okay. His entire life.
Correct.
Are you familiar with the accountings that were filed on your behalf by our office?
Yes.
And have you had a chance to review the expenses that were itemized by the accountants?
Yes.
Or, well, I don't want to lead you. What were the expenses for? Whose benefit were they for?
Garrett's.
Okay. And did you make those expenses for Garrett in good faith?
Yes.
Yes.
Mr. Berchtold, do you have any questions for this witness?
No, Your Honor. Thank you.
Ms. Brickfield?
Your Honor, yes, I do. Ms. Dosch, where is Garrett today?
Sitting right next to me.
For this hearing?
No.
Can he hear your responses?
My responses he can hear. Anything else he cannot.
And Ms. Brickfield, I note that you're not sharing your video, but for the record, Ms. Dosch has a set of headphones on.
Yes, I see that, Your Honor.
Okay, I didn't know if you could or not. Go ahead.
Right. And Your Honor, I have showing that my video is on, so I will check to make sure, see what's going on with it.
That's
so,
okay.
Dosch,
we can hear you.
Okay. So, Ms. Dosch, on November 14th of 2018, Mr. Biederman filed a verified accounting for the first accounting period that you verified. Do you remember that?
Yes.
Okay. What's the difference between this accounting and your new accounting?
Would have to compare them.
Let's see. Did you keep the receipts from December of all receipts from December of 2018 going forward as you were ordered by Judge Ochoa?
The receipts from our area have no itemization on them whatsoever.
Testimony that when you go to Walmart, they give you a receipt that says paid $120 and don't show any itemized items?
No, Walmart's over in Pahrump, 60 miles from where I live. I live in Amargosa Valley. And we have 5 markets out here, but nobody itemizes.
Okay, so that you're saying that when you go to the Smith in the area where you live, they do not give you an item?
We don't have a Smith's out here in Amargosa Valley. That would be Pahrump.
So when you shop in Pahrump, do they give you an itemized receipt?
Yes.
Okay, so all of the vendors that you shop at, which vendors do you shop at in Pahrump?
Just Walmart.
How about Goodwill?
Yes, Goodwill.
They're in Pahrump?
Yes.
Okay. And how about, let's say, what supermarket do you go to? Do you go to Albertsons?
No, those are all in Pahrump.
Those are all in Pahrump.
And we haven't been to Pahrump since March.
Well, Ms. Dosch, the period we're talking about is back in 2018 and 2019. That's why I'm asking you about those. Right.
Okay.
Okay.
Only Walmart and Goodwill would be where we shopped in Pahrump at that time.
Okay. And the restaurants that you ate in Pahrump, they gave receipts?
Yes.
Okay. And did you keep those receipts back
Yes.
in 2000? Wait, let me finish my question. Back in 2018 and 2019. Okay, did you produce all of them?
I assume so.
Okay. And what's that assumption based on?
I was asked to produce receipts, and I produced the receipts I had.
Produce the receipts you had. You do remember Judge Ochowicz ordered you in court that to keep all receipts?
No, he did not order me that. He simply suggested I put my receipts in a shoebox.
Okay, but the order from that date states that you were ordered to keep all the receipts. Right. So
No.
Well,
There was no order to keep receipts, only a suggestion.
okay. So I will represent to you that there is a signed order entered that day served on your counsel that said that. So the other question I wanted to ask you had to do with the determination. You said that I see the Amex bills have 2 users on the cards, and it's been explained. You heard Ms. Lambert's testimony. Sometimes it's Garrett, sometimes it's you. Is that an accurate representation of how it works on that statement?
When we're shopping, Garrett does his own shopping. We meet at the checker. I keep his card with me. At his purchases, he pays for by his card. My purchases are paid with my card.
Okay, so I read your Amex statements, and it looks like there's 1 account and just 2 users, and there are separate parts of the statement for each user. Is that accurate?
Yes.
Okay. So, in fact, it's you who makes the decision as to which charges are paid by you and which charges are paid by Garrett. You make that decision as guardian.
Pretty much.
Right. So it's you who makes the decisions that Garrett's guardianship was charged, let's say, for your DMV fees.
It might have been for his placard or something of his. He has a utility trailer. He has a go-kart. Would have to see the actual bill receipt.
Sure, but you're making the decision which card pays for which.
Most of the time, yes, but there are times when it is requested that he has to use his card for his purchase.
Who requests
And
that?
the DMV, for instance, would request his payment be made by his credit card.
Do you have the receipts for those DMV payments?
Yes.
Can you produce them? I have not seen them.
Yeah. There were receipts from those years, then I should have them. DMV.
If they were
I don't really remember doing business during those years at the DMV.
So when I pay for DMV, they give me a receipt that shows me what I've paid for and what vehicle I've paid for.
I got to object to the foundation.
They gave you just as you
Excuse
get
me.
the same thing?
Excuse
Right.
me. Objection. This line of questioning lacks foundation. I have no idea what transactions she's referring to.
These are all transactions set out in the accountings.
Well, that's not enough foundation.
I'm going to allow it. There's several DMV transactions that were alluded to in the objections and highlighted by the Office of Compliance because there was a question as to whether or not those items were related to a vehicle owned or not by the estate. So I'll allow it. Go ahead.
Dosch, do you have independent evidence of the payments that are alleged to have been paid by you? The accountant has testified that she said certain payments she couldn't find in Garrett's accounts. What independent evidence have you provided that show that you actually paid these payments from your funds?
Could you repeat that?
Yes. What evidence did you provide to the court, to these parties, to the accountant, that showed that payments that the accountant says were paid by you on Garrett's behalf were actually paid by you?
I don't know. I can't remember it would be whatever the accountant requested, and I don't remember what the requested evidence was.
Well, did you give her any bank statements for your own account?
No, not for my bank account.
Okay. This time I don't have any further questions of Ms. Dosch.
Goldsmith.
I only have a couple questions. Ms. Dosch, previously we were discussing a $5,000 check that was made on July 21st of 2017. Why did you feel that payment was appropriate?
Who was it made out to?
Attorneys?
Section misstates the evidence.
Okay.
I think that was hold on. That was the testimony.
I'll have to pull it up. I appreciate that. I will pull it up. Just bear with me. I have so many documents up here. It's on your accounting at Exhibit C on the worksheet of your expenses on your amended first accounting for $5,263.43. The backup document is Bates stamp Dosch 199, so I need to get there. And it says ACH Amex Payment ERAM $5,263.43 on your Amex payment. That's part of the backup.
Well, then it would be a bill for that much.
From who?
Don't have any up on that. I'd have to see the paperwork.
That have been for, it was not, would that have been for you?
No, it would be for something of Garrett's, a bicycle, a go-kart, a utility trailer, whatever.
So
I'd have to know what it was for on the check. If you've got a copy of the check, it'll say at the bottom what it was for and who it went to.
Well, I have a copy of your accounting, and I have a copy of, and I can share my screen with you. I have a copy of your American First National Bank statement, and I can show it to you. So I'm going to go ahead and I'm going to share my screen. And this document was included by your attorneys with your accounting, and it's Bates, let me get down. It's Bates number Dosch 199. I'm going to scroll to that. So when you're, this is the statement that I'm looking at, and this is, I'll take you down, I'm going to scroll down. So this is August 9th of 2017, American First National Bank. The account is in Houston, Texas. It's Garrett Dosch's account. And when I scroll, I will advise you, it's marked at the bottom of that page as Dosch 199. I'm going to scroll slowly. This is from the bottom. And I'll take you back to the top so you can see that it's the same statement, the August 9th of 2017. And then on here we have a payment of an ACH payment here. On 2017, there's two payments that are being made to Amex. And one is for on the same day. Can you tell us what those were for?
No, but they send a copy of all checks along with the bank statement.
It's an ACH payment, is what it says, e-payment. So when I go down behind the statement, I have this. So here's your daily balances. And the next document, though, goes to the next statement. That's in order. So did you have other documents that were included with these statements that you didn't provide to the accountant?
No. There is a page 3 always with each bank statement, and on that page 3 it has a duplicate copy of each check.
So I'm going to show you what your attorneys filed. So we're looking at the documents. This is what was provided to me. August 19, it says page 1 of 2. So your testimony is that there's a page 3?
Yes.
Okay. So let's
usually, well, now wait a minute. There might be only a page 2. Usually there is a page 3. But I would think if there's just little activity, they would only have page 2 possibly. But there should be a copy of each check.
So I'm going to scroll through. This is document Dosch 199, this first page. And I was asking you about this payment. Payment right below for $5,263.43 and asking, they're both paying Amex. I can't tell what they're for. And let's see if there's any more help on the next page. Let's go to Dosch, page 2. I just have ending balances. This is the page 2 of the statement, and this is Dosch 200. When I go down to the next document, which is Dosch 201, that takes me to the September statement. So, are you able to give us testimony today about those 2 expenditures?
No, not without seeing the check.
I have no further questions, Your Honor.
Thank you. Ms. Cole?
I have nothing on that.
Thank you so much. And Mr. Berchtold, Ms. Brickfield, do you have anything else?
If I could ask her a few questions, Your Honor, I'd appreciate that.
Please, go ahead.
Good morning, Rain. How are you?
Pretty good. How are you?
I'm good. So, generally, how would you describe your lifestyle?
Poverty. It is very difficult, or has been in the past. The settlement, both the twins' settlements were structured so that Travis got nothing until he was 21, and Garrett's was started out at $2,000 a month. And in the original paperwork, it says it's for both twins, $2,000 a month. So you can imagine how difficult. Then it went up to $3,000, but not for years. So that they were raised on $2,000 or $3,000 a month, which does not provide too much. And I have taken an early Social Security because of that. And of course, the Social Security doesn't cover too much.
Yeah. During the course of a day, how much time do you spend where you're not either in a room with Garrett or in the same house with Garrett or have your eyes on Garrett? How much time do you spend away from Garrett?
8 hours approximately when we're in our own bedrooms at night.
So otherwise, you're pretty much in the same room, the same house, or you have your eyes on him somehow.
Well, we're always doing yard work or animal work or housework or some kind of work together, yeah. He's my main ranch hand.
Do you take vacations without Garrett?
No.
Do you go out to eat without Garrett?
No.
Do you go out for nights on the town without Garrett?
No.
So, during the time period we're talking about, do you recall making any major purchases that in some way didn't have something to do with Garrett?
No.
Do you understand that going forward, the court and myself and everyone on this call would really like you to keep receipts?
Yes.
Okay, that's all I have. Thank you.
Anything else from anyone else?
Yes, Your Honor. It's Elizabeth Brickfield. I have just a couple of questions to follow up with Ms. Dosch. Ms. Dosch, at your deposition, you testified that you received Social Security income of approximately $2,000 a month. Do you recall that?
Yes.
Okay. And you do receive that at this time?
Yes.
Correct? And during this period of the guardianship of these accountings from 2017 to 2019, Garrett is also receiving approximately $4,000 to $4,500 per month
yes.
in distributions. Right. So that's about $6,000 a month, right?
Correct.
How much of the guardianship expenses are directed at occupational therapy or physical therapy for Garrett during that particular time period of 2017 to 2000?
Well, he's got insurance that covers that.
Okay. So there are no copays?
He's got a couple copays, but they're like $20.
I see. Right. During that period from 2017 through 2019, was Garrett receiving occupational therapy or physical therapy?
No.
Okay. And during this period of 2017 through 2019, did you at that time request a payment to you for guardianship for your caregiving duties to Garrett?
No.
Okay. I have nothing further, Your Honor.
Anything else to follow up?
Just briefly, do you know how much money has come out of Garrett's estate to pay for evaluations that were requested by the guardian ad litem?
Probably about $9,000.
And then there was another check from this accounting period, right?
Yes. Yes, for about $3,900.
And how many hours were you subjected to a deposition by the guardian ad litem in this case?
7.
And how many?
Your Honor, I wanted to make an objection to relevance.
Cool. How's that relevant?
Fees coming out of the estate. Garrett's estate.
I'll allow it.
And how many attorneys were present at your deposition?
Oh, well, they weren't. It was all done telephonically.
There was multiple attorneys present telephonically,
Well,
correct?
right.
And a court reporter?
Yes.
And transcripts were requested?
Yes.
Okay. How many hearings have you attended that you did not receive multiple objections?
Very few, if any.
Response, Mr. Berchtold, Ms. Goldsmith, Ms. Brickfield, anything? Mr. Berchtold, I'll start with you.
No, thank you, Your Honor.
Ms. Brickfield.
No, Your Honor, but I want to just notify you, I have to sign off and sign back in. So I'll just be gone for a few moments.
Okay. Any other questions?
I just have a couple questions. Ms. Dosch, why do you feel you need an accountant to help you in an ongoing basis to do the accounting?
Object, I don't think that was her testimony.
Counsel, why don't you rephrase that question?
All right. Ms. Dosch, do you feel qualified to do the accounting on your own?
Not like it is. Previous accountings, early accountings, I could do. An extensive accounting like this, there would be no way. This is a forensic accounting.
So going forward, that's not forensic. So for the 2020-21 year, do you feel that you could appropriately allocate expenses and income into the appropriate columns and prepare your own accounting?
No. It would have to be verified by a professional accountant. Everything, there would be nothing I could do that would be accepted.
You don't feel if you provided the receipts and did it on your own that the accounting would be accepted?
Objection, argumentative.
I'll allow it.
What?
Go ahead, Ms. Goldsmith.
Do you feel your accounting would not be accepted?
Because I don't have the right credentials. I only have a degree in architecture and one in medicine. I do not have an accounting degree.
Have you reviewed the Nevada statutes with regard to what's required to be in your accounting?
Yes.
And why do you feel you cannot personally complete that task?
Objection, asked and answered.
Allow it. Go ahead, Ms. Dosch, you can answer that question.
Oh, okay. I would just feel that a professional accountant would be more accepted by the court.
Do you believe you're more qualified to be a caregiver than a guardian of the estate?
Not really, no.
And why is that?
Because I can do both fairly well, as long as I don't have to have everything itemized and everything like this accounting was a forensic accounting. I realize that. But in the past, no, I don't feel I could do it. And it would not be accepted by the court. And yes, I am a good caregiver and I can guard the estate. I am good at simple accounting, nothing like this. And I don't have, for instance, where we live, there's 5 markets out here and nobody itemizes anything. So that would be a problem right there. And I'm not moving. And then out here, they don't accept personal checks. They don't accept credit cards. In many of the places, some do. A professional accountant knows how to deal with a problem like this. I don't.
Have you considered having the cashier sign something for you when you pay cash to verify what you've received?
They'd have to make a list of everything purchased.
Well, your accounting refers to items like just groceries. So if they've said groceries and they had, if you have it, do you go with a shopping list to the grocery store?
No.
Your Honor, I have no further questions.
Ms. Cole, anything else?
No, Your Honor.
Thank you so much. Thank you, Ms. Dosch. Ms. Cole, do you have any other witnesses?
No.
Counsel, based on that testimony, does it change your objections or oppositions to the accounting? Mr. Berchtold.
No, Your Honor. I mean, I didn't have any objection to the counting in the first place. I think as the accountant testified, there was some vagueness initially when Rain took over. The accountant, her maintenance of the accounts has gotten consistently better. It's obvious she doesn't lead an extravagant lifestyle, and there is no indication that there's any intentional sort of theft, any kind of misappropriation from the estate. There are simply no red flags to that. Maybe there is a guardian who is not a perfect accountant. That's like a lot of other guardians. But I think this accounting, in some sense, this hearing is sort of deja vu because we're hearing the same objections over and over again. And if this is the case, we will never get an accounting approved. The big picture is the expenses are very minimal. Garrett lives independently. He has a full-time caregiver. So none of this is unreasonable. So I have no objection to the accounting.
Mr. Berchtold, as to the retroactive request for guardian fees and that about 50 that we spent some time discussing in 2017, what's your position?
So I think it has always been a struggle, as it is in many other guardianships, to figure out how to account for caregiving services when a protected person lives with a family member. That's always a difficult thing, and that has been an ongoing discussion in this case to try to figure out how do you account for a valuable service that Rain provides to Garrett that would be far more expensive if Garrett had to go and get those services elsewhere. So I have no objection to accounting for it and figuring out how to, not only on a going forward basis, but from a retroactive basis as well. I did have some question about, now my impression is, and I just want to clarify this, there is not a request being made for actual monetary payment from Garrett's estate for 2017 and 2018 to Rain. That money's already been paid. So what we're really talking about is just accounting and characterizing money in a different way. Is that correct?
Ms. Cole?
So for the 2017 accounting period, there were significant amounts of crossover between Rain paying some of Garrett's bills as well, which never came up today. So no one had an objection to Rain using her personal money to pay Garrett's bills. It was that one bill that went on Rain's credit card that was discussed today. But overall, there was a higher amount that Garrett paid from his estate on Rain's credit card than the other way around. You can see that from the accounting. So for 2017, we wouldn't be asking for retroactive reimbursement for that accounting period. For the second accounting period...
Hold on a second. So hold on. Let me just clarify for Mr. Berchtold. Does that mean that you're requesting that money that was paid from the estate to Ms. Dosch's personal credit card, that now be construed as guardian fees and be retroactively approved by me?
Yes, I'm asking that it not be requested that Rain reimburse the estate for those fees, for those payments, because of two general reasons. The first being, when she came on as temporary guardian, there was some confusion with the funds. She didn't have access to all of the money coming in for Garrett, and she did have to use her card sometimes, and then Garrett used his card to pay her sometimes at the beginning. And as Mr. Berchtold correctly identified, that has been resolved. It is very, very bifurcated now, and has been. Even through the second accounting period, there was only a few $100s that happened to. Now, so for the first accounting period, yes, we would ask that the court basically call that slate clean and not require either, Garrett to have to reimburse Rain for payments she made from her personal account to his estate, or vice versa. And that we also find that there wasn't an intent to conceal or misappropriate any funds from that accounting period, if that argument was going to be raised regarding that payment that was discussed today. For the second,
Mr. Berchtold, hold on a second. Mr. Berchtold, does that clarify the issue for you?
Yes, Your Honor. I have no objection then to with respect to the first accounting. I have no problem.
All right. Ms. Brickfield.
Your Honor. So I'm looking at the petition filed by Ms. Dosch that asks
It's extremely loud.
I'm sorry, let me make it.
She's shaking her head yes. Go ahead.
All right. So it looks like the petition initially asked for $79.78.20 in reasonable guardianship compensation for the first accounting period. Am I understanding Ms. Cole correctly that you are withdrawing that request?
I think I already said what my request was regarding the first accounting period in my.
Right. So that portion of the request is withdrawn. Is that correct?
To the extent that it's cash to my client, yes. But that amount that would have been reasonable compensation is very close to the amount Garrett paid from his estate on my client's credit card. So if that had been approved as just a direct transfer, clearly that would have been reduced by how much she had already received. But yes,
So,
you're foregoing the other $800 or whatever it is.
well, no,
That answers your
actually,
question.
when I looked at your petition, you asked for the first year, and I just want to make sure it's moot, you asked for $13,200 for each year under this accounting. You said for the first period, Ms. Dosch was entitled to an additional $79.78.20. You said for the second period, she's now claiming $12,193.78 in unpaid fees. So the first request you're saying is withdrawn, and the standing request right now is for $12,193.78 for the second accounting period? Is that how I read your petition correctly?
Well, the court hasn't asked me to respond about the second accounting period. I was only permitted to
Only
speak
on the first one. All right. So, Your Honor, Ms. Dosch has made it apparent with regard to the first accounting period that she hasn't kept receipts and that she made the decisions as to what would be charged to Garrett and what would be charged to her. I believe, and I said in my objection, that people should be paid for the work they do. But that work should be, and that fee should be specified as a fee. It should be deemed income to her, and we should not be going through as we go forward and saying, okay, this expense is going to be compensation and this is not. There's no documentation that we've seen, and the accountant testified she didn't see any to substantiate the payments that Ms. Dosch says she's made and she wants credit for. And there's no documentation to answer the question about what the money was spent on. So
That's not true.
excuse me,
Okay.
let me finish. And so while I understand that this is the third time we're going through verified accountings, that the accountings really haven't changed and we haven't answered the fundamental questions, I understand that we may be in a point that we have to look forward rather than retroactively again. I do not think, in terms of this petition to pay retroactive guardianship fees and accounting fees, that it's appropriate to have an estate that's got $300,000 in it paying this kind of accounting fees. I think that should be charged to Ms. Dosch. She's had attorneys before who prepared the accountings. Some of them have been paid by this court for this work. And so yet now we're going to have a third group getting paid. But if this court is inclined to award fees for accountings that Ms. Dosch says she's not qualified to do, then I think that should be deemed part of her compensation and not additional compensation.
Ms.
Thank
Cole,
you.
you wanted to say something?
If you're asking for me to make comments on the first accounting, I do want to make a note that the accountant was never asked if she verified the payment from Ms. Dosch's credit card. No, she testified that she didn't look at Ms. Dosch's bank statements, but that was not a payment to Ms. Dosch's bank statement. It was a payment to her American Express credit cards, and every single American Express credit card for Garrett has Ms. Dosch's charges and payments as well. They're combined statements. So yes, it was a payment from Garrett's card to Ms. Dosch's card. It appears on every single statement, and it shows what Ms. Dosch spent. So yes, the accountants were able to review those, but they were never asked that question. They were simply asked if they looked at Ms. Dosch's bank statements. So again, we're going around and around about this one charge that was made in the beginning of the time that Ms. Dosch became guardian, when she was mostly temporary guardian during that period of time and did not have access to the funds from Mr. Gottesman, who, and I put this in my petition, elected to give her money occasionally. I mean, she went a few months without getting any payments at a period of time in the first accounting. Nothing to be able to support Garrett during that period.
Ms. Brickfield?
So Your Honor,
my comment is that every time we go to court on anything Ms. Dosch does, even as nitpicky as make the clerk write a list for you of what you purchased, we're getting objections. So I can understand Ms. Dosch's trepidation being the one who does these accountings when even the CPA firm is being barraged with objections and questions and dissected for their work. You're right. Most guardians come to court and they're not asked to produce every single receipt. Ms. Dosch has been asked to do that, but when she produces a receipt, and that's not good enough to say, I went to the store and bought groceries, I want to know who ate the groceries. How is she supposed to come out of this with any kind of vindication that she's doing what she needs to be doing when she's set up for failure to come in every single time by the type of nitpicking objections that cost thousands and thousands of dollars on all sides? We've got the Legal Aid Center resources taking up hours of these hearings. We have a guardian ad litem who knows what her bill is at this point. Dara Goldsmith, who's charging her client, and our fees, and the accountants. Everyone is spending hours on these issues. And my thought on why there's such a strong objection, because it just doesn't make sense why there's such a strong movement by the guardian ad litem and Ms. Goldsmith to unseat or take away the guardianship of the estate from Ms. Dosch, is that they do want an institution to take over. And let's pay an institution to do it. That's what it appears.
Ms. Cole, I think your statements are misplaced. I don't know if that's their intention or not, but it's never been expressed to me. It's always been expressed to me that Ms. Dosch is appropriate caregiver. And I think this goes far afield from the issue at hand. Ms. Brickfield, you want to respond?
Her spending is under $4,000 a month in my accountings.
Ms. Brickfield.
Your Honor, there are plenty of guardianships where we're clear about what are the guardian's caregiving expenses and what's paid to them and what the guardianship's expenses are. It is clear here that there's been a commingling at best of expenses and payments, and my concern is that as we move forward in this matter, we should move forward in a manner that allows to make sure that Garrett has sufficient assets for what is going to be hopefully a long life where he's going to need a lot of care. And so my concern about this accounting has always been that we don't have any documentation other than now the same Amex statements that we first saw in 2017 and 18. We haven't moved any further. But I appreciate that the court, and I'm also concerned that a guardian comes in and says, I need an accounting firm at rather high rates to do what is a simple accounting for a guardianship where we're talking about $48,000 or $50,000 a year at best. There have been ways proposed, there were ways proposed today that we simply, pay Ms. Dosch a salary going forward, that she get a certain amount of money in expenses and that she account for that. And that may be what we need to do. But we need to consider going forward whether it's appropriate to have a guardian of estate and approve accountings when there is no evidence to support it, there is commingling going on, and we're not even clear what assets are Garrett's and what are not. You yourself, Your Honor, pointed out earlier that there were years when Ms. Dosch did not account where she served as guardian of both the person and the estate, or when she just served as guardian of the person. And so, and with regard to the alleged months when Ms. Dosch did not receive funds for Garrett, she was represented by counsel during that time. She received funds that she asked for. That amount was discussed in court. And I also note that for 2 or 3 months in there, she took more than the amount she was supposed to take when the accounts were unblocked. And that should have, in fact, evened this all up. So I appreciate that we need to come for an end for this today, Your Honor. I simply ask that whatever we come out with, that it be in Garrett's best interest, that it acknowledge the need to plan for his care in the long run and to make sure that he's getting the type of therapy he needs now. Thank you.
Counsel, go ahead, Ms. Cole.
Just one comment. I just want to again reiterate, the only time period we're talking about where there's any commingling in question is the 2017 time period. There is no evidence, and no one even made a single objection to the second accounting that we prepared. First of all, no objection. So that should simply be accepted based on lack of objection. But the second accounting period has very little commingling. I mean, de minimis commingling. Coming into the third accounting period, as the accountant testified, very organized, very bifurcated, very separated. So to make the argument that Ms. Dosch is playing loose with the accounts and she's commingling everything is simply not true. I needed to correct that for the record.
Your Honor, if I could be heard, I did object to the second accounting. In my accounting, I talked about the payments that are in there, and I did object to them. I also objected in here to the inventory and to the lack of information about what assets are where. But I recognize that we need to move forward, and so I'm not going to go any further with it. Thank you for your time.
There was a
Your Honor?
number of explanations in my first accounting about everything in question that's been argued that maybe Garrett's or maybe Rain's. So I asked, as my response to that, I believe that's been sufficiently explained, and also the evidence of the title owners of every asset was attached.
Your Honor, if I may,
Go ahead, Ms. Goldsmith.
with regard to the second accounting, and I want to point out that I didn't receive the backup to the accountings until Friday afternoon. And so my objection, and it's the same objection I had in the first accounting, the old first accounting, is the lack of receipts. And that was what was required by OCHOA. That was what was directed. I was hoping I'd get receipts when I finally got the documents on Friday afternoon. I don't think that the court expected me to whip together an objection when I get documents on Friday afternoon that I had requested back in August. But be it as it may, I'm trying not to incur additional fees for anyone in this matter. I think that, there's grave concerns with regard to the inability of Ms. Dosch to follow the instructions as a guardian to keep the receipts. It may be that there just has to be a budget going forward for her cash expenditures, and that, she signs under good faith that that's what happens. But I think that with regard to the activities previously, these accountings are just, they remain insufficient. And it's my objection remains the same. It's just repackaging of the same information. And I think that, hopefully we can get her on task. I think that it is her responsibility to do the accounting. A $50,000 accounting, a guardian should be able to do, a guardian of the estate. And to the extent that she chooses to retain someone, because even a law firm doing a recapitulation is going to charge maybe, $2,500 for doing a recapitulation, giving, boxes of receipts, or $3,000 or $3,500. But I don't think that Garrett can afford this going forward. the cost of the accountants doing this. It's not in his best interest. And I'm hopeful that she can, learn how to, put the receipts in appropriate baggies or something of that nature, or buckets, so she can keep track of the expenses and someone can prepare the accounting for her in an easier fashion. But I just think that the court has to be concerned that her own testimony, she can't defend the expenses.
Thank you, counsel. Today, I'm going to issue a written decision, but I am going to accept the accountings today. As to the requests about the guardianship fees and attorney's fees, I would like to do those in separate orders, so that each order approving and accepting the first accounting separately from the second, separately from the third, and then a separate request relative to fees, separate as to accounting fees, separate as to attorney's fees. Counsel, I appreciate that may be some additional work, and in a case that has a lot of pleadings, it may seem duplicitous, but I'd like to single out those orders for purposes of appeal and also clarity moving forward. I will ask first Ms. Cole to submit those proposed orders approving separately the first accounting, second accounting, etc. Under the statute for attorney's fees, I have to make some 19 to 29 findings. And one of those findings, clearly I didn't write the statute, right? So one of those findings is whether or not the attorneys were successful. And so because of that need for that finding, I would like to make that decision last. And so I say that on the record that I will see Ms. Cole's orders. I'm going to ask Ms. Cole not to send those to the proposed orders box, but send them in Word format to my law clerk. I am telling counsel that I will consider last the request for attorney's fees, and I consider that, although it's contained partially in the same petition and request, that issue is obviously considered last for me. I do have a question, and I know that each of you, Ms. Brickfield, Mr. Berchtold, and Ms. Goldsmith, has raised this issue today, and I asked Ms. Cole and Mr. Willick about going forward. Is there any appetite for, in the future, a monthly allowance to Ms. Dosch? And I don't know if allowance is the wrong word. Certainly, she should be paid for her work as a caretaker, as a guardian, to the extent that those roles are sometimes different. I know that they overlap during different parts of the day. Have you had those discussions, Ms. Cole, with counsel about a proposal moving forward? My worry is that perhaps, from Ms. Dosch herself, she may be unable, after hearing her today, to prepare these accountings in the future. And it sounds like Ms. Brickfield, Mr. Berchtold, and Ms. Goldsmith are kind of on the same page on that issue. Have you discussed that about going forward, Ms. Cole?
So when I first came on the case, we floated several ideas that were actually initiated by Mr. Berchtold, as he's been on the case obviously much longer, and his idea was, why don't we just allocate a set amount per month that RAIN can use rather than have a requirement to itemize everything every accounting period. Now, I want to make it clear in my mind how I understand it. If RAIN, yes, guardians keep their receipts, they keep their bank statements. I understand the obligation to do that. If they are required, based on the parties in question, in this case, the parties in this case question, to produce and itemize every single receipt, even as small as $2.50, that will be an expense that someone will have to bear. Okay? Because that is a lot of work to organize, itemize, and produce those to the court. If my client is not required yes, she can produce the bank statements and the credit card statements that are itemized showing what she spent. Those can be produced by my office by being Bates stamped in a single lump. I can get those produced, no problem. But if she is to itemize and produce every receipt, which is very uncommon from what I understand from Mr. Black said, but it is possible. So in this case, it was requested. If she's asked to do that every accounting period, we will have to deal with thousands of dollars to someone, attorneys, and no, it's not going to take $2,500. And if it is, it's going to be the quality that you received the last time that was rejected. So someone's going to have to do that.
So first, let me say this. It's not uncommon where there's questions in
Sure.
accountings and long cases. I appreciate Mr. Black's perspective and his advice to you.
Well, I know that everything over $250 is generally submitted, and I understand that. But to have to itemize every single receipt, that's just simply going to cost a lot more money. So
I think
we have
the
to decide, are we going to
question
be coming
was-
to court every year and having this level of detail presented? Because if that's the case, we're talking about a whole different budget than if she submits reconciling the statements with the budget being under a certain amount, and then she submits her bank, Garrett's bank and credit card statements and circulates them. That's going to be a much smaller expense overall than having to do this level of analysis that the accountants have done. And that, frankly, my office had to do because it's very tedious, very time-consuming work to go through every single itemized expenditure. So I think we do need to decide as a group, is this something we want to put her through every single year? Because if that's the case, then we need to talk about that level of cost.
Okay, so it sounds like no, you have not had this discussion.
We haven't had that discussion. No, we did float some ideas that was never agreed upon. I haven't had a single issue agreed upon by the guardian ad litem and my client in this case. So I would love to.
I don't know. It sounded as
that.
though, Ms. Cole, I don't know if you heard Ms. Berchtold a few moments ago urging the court to move forward, although she had concerns.
Yes.
The request was that we accept your accounting and move forward. So I don't know that she's met you in a polarizing way at every juncture.
No. I'm open to negotiating and resolving this in good faith.
Well, I don't
I'm
know
just
that it's
saying
a
up to this
negotiation.
point-
I will tell you this. The statute does not allow you to negotiate around the accounting requirements.
I understand. And that's not what I
However,
meant.
and Ms. Cole, I'm not saying that to you. I'm saying that to everyone on this call. But Ms. Brickfield, Ms. Goldsmith, Mr. Berchtold, all in their comments today discussed if Ms. Dosch is having difficulty for whatever reason about managing the estate, retaining receipts, or bookkeeping and accounting, perhaps a resolution is that we make an agreement, or that you make an agreement moving forward, that she be given, based on it would start with a budget amount, and Ms. Brickfield has been over this a few times, that we would, say X amount is for food, hygiene, and personal items each month. X amount is for whatever, based on your budget, and you make these stipulations based on what their needs are, the income, how those things change. And, the large expenditures need to be approved by me anyway, by separate petition. That's not just something that we deal with in the accounting always. But if we anticipate those, I think that's easy for, did we lose Ms. Brickfield again? And Mr. Berchtold, I'd ask you to head up those conversations. And it looks like Ms. Brickfield just joined us back again. Mr. Berchtold, what do you, for the record, so that everyone hears today, what do you think when you talked about that today? What did you anticipate a suggested agreement might be for moving forward?
I think my suggestion was pretty general, Your Honor, and I'm open to any ideas that anybody might have. But I think there has to be some way to simplify this moving forward. And I think the simplest way would be to agree on some amount that is released to Rain every month, and it is agreed that it is for X, and that's what she has to account for. Easy, simple. The more simple we can make it, the better. So I am happy to head up conversations and talk to everybody about what we might be able to come up with.
And certainly, whatever agreement, and Ms. Brickfield, I know we lost you for a moment, but I asked Mr. Berchtold to head up those conversations with Ms. Cole and with you and Ms. Goldsmith to discuss a plan moving forward that's extraordinarily simple, very easy to follow, that's set up step by step with the assistance of Ms. Cole and Mr. Berchtold and you. Certainly, I don't think that you can stipulate around our annual accounting hearings or the requirements of retention of receipts. Those things are just required by statute, and I don't think the statute gives us wiggle room on you. But certainly, if you asked me to remove Judge Ochoa's order that he previously issued, because you think for good cause you have set up this plan or budget moving forward, I would be inclined to do that if you all stipulate it. Does that give you some direction, Mr. Berchtold?
Yes, thank you, Your Honor. I'm eager to have those conversations.
Is there any other thought on that plan moving forward that anyone would like those on the call to consider as they move forward and discuss those things?
One comment, Your Honor. You kind of alluded to the fact that we've proposed a budget, and I just want to note for the record, our budget is $4,500 a month. That includes the guardianship fees. So as a starting point, I would ask that Mr. Berchtold review that and we can start talking from that point. But if there are objections to having this resolution, then I need to have those identified specifically by anyone else in the case, why we can't move forward to a resolution. Because I do want to state for the record, so far, I have not had a single issue agreed upon yet since I came on this case.
For the record, what I'm proposing, what Mr. Berchtold, Ms. Goldsmith, and Ms. Brickfield alluded to, is not a resolution. It would be like a helpful framework, Ms. Dosch, moving forward.
It requires working together.
No, it would assist Ms. Dosch, but we will see each other every single year for an accounting hearing. I cannot change that. Guardianship cases are never resolved. They become an issue every single year for the person's entire life. So there is no final resolution. There is no order that resolves a case until the guardianship is terminated. So this, I think, is a helpful, creative way to ensure that Ms. Dosch's duties are simplified for her in an effort that helps her spend more of her time on caretaking and supporting Garrett and less of her time on accounting, which she, by her own admission, is hesitant to engage in and hesitant to perform. I'll tell you, I didn't hear from Mr. Berchtold or Ms. Brickfield they want any other person to be his caretaker other than Ms. Dosch. So I don't think that's the issue. Today, I'd like to give her a helpful framework. It seems like she has misunderstood some of the orders previously in this case, and I know it's a very old case. And I want to make sure that she understands those in a way that's simple, easy. It's not a complicated estate. Moving forward, let's try to make it easier on her and support her in a way that makes sense and meets her where she is. Look, they have a unique situation as she described, right? So we need to support her in that. That's all. So it's not a resolution. I think it's a roadmap for her. that I think she would be probably very happy to have, so that everybody's on the same page moving forward. Now, it's not like a promise, you know, it doesn't mean that she goes unchecked, and we won't have accounting hearings in the future, no. But for guardianship fees, council knows exactly what under the statute I need. And if you're considering a lump sum guardian fees payment in the future, you know that I need a detailed summary of what that includes. And an example would be transportation to and from each and every doctor's appointment each month. He has approximately 4 doctor's appointments each month. Transportation to and from the library 3 times a week. You know, so that kind of thing. I think that would take care of what the statute requires, which is specific, detailed examples of what those guardianship fees are. When we see those from other guardians, they're not approved unless they're an hourly description, much like an attorney's billing. But I'd be willing to take a summary of what she does for him, described by you, Ms. Cole, so that for the month, you know, an average of what the situation is, because they are living together, so it's a little bit different. You know, each month might be a little bit different, but there's a lot of consistency.
Right.
And give that to council, and I'd be willing, and I think under the circumstances, that would suffice the requirement of the statute.
Right, and understanding that her testimony is she's with him every day, all day, except for 8 hours when they sleep. So that would be...
I understand, but that's insufficient for the requirements of guardians fees under the statute. So I would need you to get us more.
Of course, and it's just going to be a very extensive schedule. But yes,
sure.
we can go through that, and that is not a problem at all. I can do that for the court.
Well, and I don't necessarily need it. I think that Ms. Goldsmith, Mr. Berchtold, and Ms. Brickfield need it, and that it should be that summary should be attached to whatever agreement that you sign.
Yes, Your Honor.
And Your Honor, I want to point out, I take issue with Ms. Cole's statement that I object to everything. I think it's clear that recently, with regard to the One Main account, we all agreed that line of credit should be paid off and shut down. I mean, you know, we're all here for what's in Garrett's best interest. That is why everyone is in this room. With the exception, hopefully, I guess, Mr. Berchtold, he's going to do what Garrett wants. But, you know, that's the objective here, is to make sure he's getting the right services, he's being treated fairly, he's getting the appropriate occupational therapy, appropriate stimulation, appropriate ability to communicate, improvement. That's what it's all about. Everyone wants to make sure that Garrett's getting what Garrett needs. I think that's, and sometimes maybe people lose sight of that, but that's the objective in this case. It's none other than that.
Counsel, is there anything else I can do today? I'm not going to set a status check. I will issue those orders as I receive them from Ms. Cole. I anticipate, and I'm going to ask Ms. Cole to send them, I told you, in Word, so that I can add additional items. I'm not going to set a status check for your agreement. I just ask you to continue working on it. If you need to set it for hearing, you can, or you can just file it with me. Ms. Brickfield, you raised your hand.
Yes, Your Honor. I have one concern. I think this is an excellent plan going forward, but I'd like for you to consider tasking Mr. Berchtold and all of us to have a discussion with regard to the funds that are beyond the budget. Right now, they are sitting in a bank account earning essentially nothing. Garrett is 42 years old. He has a long life expectancy in front of him. He's going to have substantial expenses moving forward if he needs, as he's going to need 24-hour care, regardless of where he winds up staying when Ms. Dosch is unable to care for him. And I'm not sure that any consideration has been given in this matter recently to whether or not any of these funds should be invested, even in something as simple as a mutual fund or something like that. It's just so I'd just simply like us to be tasked with that discussion as well.
I think that could be part of your discussion, certainly, and so that you could get Ms. Dosch's investment goals or her thoughts, every temperament for investments, certainly, for that money, and then have all council weigh in. That could be part and parcel of your plan for the future. And if you stipulated to an investment philosophy or plan and a specific person to manage that, if you wanted that to happen, I'm happy to consider that as well.
Your Honor, I have a couple points going forward. We haven't, Mr. Goodsell filed his report with regard to the Special Needs Trust, and we had everybody had a meeting with him as well after, and we discussed some options, and so I think that that's still an issue that's out there. There were things when we discussed it, that he hadn't considered. Looking at the long term when he receives another distribution and why it would make sense to have him in a first party special needs trust with a payback provision to the state for benefits he receives. I don't think we've fully fleshed out that he's not getting the necessary occupational therapy or things that he would be entitled to. And I think what's clear, and this is probably something that's just still needs to be managed, it's clear from the deposition testimony that the guardian hasn't taken the necessary steps to get a lot of those things done over the years, and that he didn't have, once she pulled him out of high school, he went 25 years with none of this. So I think it's important for us to still keep that on the front burner and address that going forward. And it may be that we have to have a hearing with regard to Mr. Goodsell's position, and so we can fully vet this. But I think that's going to be not putting the cart before the horse. I think we have to determine this budget issue and determine what remains. And I think that that's still kind of part and parcel of what needs to happen. So I think that matter is still on the burner. I think that just like Ms. Cole filed that report, and we're going to be filing with regard to some visitation issues we're having. And that needs to be, hopefully, I mean, I'd prefer not to have to file something. I'd hope that we can all work towards having that happen in a more meaningful manner with using Google Duo, which is what this court has ordered, which has become it's an unmanageable situation because they're not willing to use Google Duo. But anyway, that's for another day. The other thing I would point out is on a bookkeeping matter with regard to the petition on Old Main, that's still set on calendar for December.
I'm sorry, and that's in my
vacated.
notes. Yes, that should be vacated, and I thought that I did it at the last hearing, and I didn't, so thank you. I'd ask you, and I know that there's some overlap in these financial issues and also the other issues regarding a care plan, and I know Ms. Cole, because they have some financial impact. However, that being said, I'd like to talk about and get a resolution first about those guidelines and things we talked about initially, because I think we need a win. I think we need for everybody to be able to agree on something first, okay? And so I think psychologically that's going to help many of you to be able to agree on something and go through the process of discussing it, agreeing, and making a plan. Ms. Cole, I had a couple of questions. Last night when I was reviewing some of the old documents in this case, a lot of the report of guardians, and I don't know if you are even in I know this is kind of off topic. Garrett's mom, when she filed the reports of guardian annually, she indicated that she was a counselor and physical therapist. Is she a licensed, trained physical therapist? And is she? And she says she provides him physical therapy, medical and psychological care. I had, we talk about occupational therapy and speech therapy and those things. Tell me the extent, if you can, and maybe you're not prepared, but when I look back for years and years, that's something that has been a reoccurring theme in her reports of guardian. So I just wanted to know what her education and licensing is. Today she told us that she was had a medical degree and also an architectural degree. That's a lot of degrees. So,
yeah,
Ms. Cole, that's what I wanted clarification about.
Sure. And I can ask her specifically what therapy she provided Garrett over the years in a moment, so the court can clarify that question, because specifically I can't tell you, between these years she provided certain therapies how many times a week. But I do want to address, and it's very important that I address what Ms. Goldsmith says, because not only was it not what I understand Mr. Goodsell's opinion was, Mr. Goodsell analyzed the issue of a special needs trust. And basically his conclusion was, unless Garrett needs some range of services between, I believe it was somewhere in the range of $8,000 a month, where he receives that $5,000 annuity, then it makes sense, because maybe he moves to a home or like the Desert Regional Center or something like that that requires a higher monthly fee than he receives. Then he could apply for Medicaid, which would be absolutely acceptable to apply as long as he's under the age of 65. And recall, he's 42 years old now. So anytime within the next 23 years, if that occurs, that he requires a higher level of care, that requires a higher monthly expenditure, then he can always apply for a special need trust and get that Medicaid benefit to pay for a portion of those fees. But for right now, he's not going to get any benefit from a special needs trust. And I had Mr. Goodsell here today because I anticipated that argument would come up. I'm very inquisitive as to why this is being pushed so hard, when I have a vetted, experienced estates attorney that said he under no circumstances would allow his own child to get a special needs trust, because it puts the control in the hands of a third party that's not your family. They decide what they're going to do with your medical care, your income for your child. Not only that, you're limited to Medicaid only options, and Garrett has a very good private insurance right now. The financial benefit is zeroed out. Why are we going to keep this on the burner when we've already established the fact that not only does he not need that right now, but he is receiving therapies? We have Dr. Consora, who I had this morning, come to court in case this came up, saying he gets all the occupational therapy he needs from the ranch. He's getting therapies. He's getting teletherapies for speech. He spends time working physical labor on the ranch, and he's happy doing it. He doesn't want to get in the car and spend 3 hours twice a week driving to Vegas so that he can get a physical therapy that he would get in Amargosa Valley. So sure, we can talk about this later, but what's the real benefit to Garrett here that everyone's pushing so hard for, when we even have an expert that we spent $12,000 on saying that one says he has two trajectories in life. Both of them are beneficial. One of them is stay on the ranch and do his ranch activities and get his therapies in Amargosa Valley. Equally beneficial, possibly, driving all over to Las Vegas and getting therapies. And then we have Dr. Consora, who says, I don't see the need of any of this. He's getting what he needs in Amargosa Valley. As long as he's getting those communication therapies, he has what he needs. So we're going to spend more time and more money and more fees arguing about something that arguably does not benefit Garrett. And we have two experts that say so. So I do have an issue with that.
Okay, so this isn't on the calendar today. I asked that you try to make a resolution regarding the budget and a specific guideline moving forward. My question, Ms. Cole, was, as I saw that in your care plan, I don't see information about moms providing physical therapy. I hear from you the general, and Mr. Consora, and Dr. Consora, the general idea that he's receiving, as he does that labor on the ranch, that he receives a lot of therapy that way. My question just was to you, and perhaps I've missed it, is that if she's a licensed physical therapist, perhaps, as she says in her report of Guardian year after year after year, is she? Can she do the physical therapy? Is it more detailed physical therapy going on than I've been led to believe at this point. So Ms. Cole, I just mention it, and I don't need an answer today. I just think that if she is trained in physical therapy, that's also another option. Perhaps he could be evaluated by a third party, and she can be instructed by that physical therapist how to do the exercises. I think that would give you what you want, which is that he remain on the ranch and not have to go to those appointments. I guess my question just was that I did not know that she was a licensed physical therapist.
He has a physical therapist in Pahrump. Yes, I'm not sure. My client is more advanced in years. I'm not sure if she still performs it on him. I mean, we can ask her right now.
No, that's okay.
It's a good idea. It's a creative solution to saving some time and fees.
Well, it seems like a lot. She's a med tech, a psych tech, a counselor, physical therapist, careers and hobbies of interior and architectural design, landscaping, ranching, gardening, animal care. She provides physical therapy and medical and psychological care to Garrett. And so I just, and today she's his everything, I know. But I just wanted to raise that to everyone and, let that be a little bit of a homework item. Okay, anything else I can do today?
Just on these orders, I have a question of how you want them organized. Do you want me to do separate orders approving the accounting, separate from the accounting fees, separate from the attorney's fees, and have them all separated between the first and second? Okay, I just want to make sure.
And I know that's a lot of orders, Ms. Cole, but I think that it is appropriate given kind of the backlog of things. It will help us straighten things out.
Get those submitted.
Ms. Brickfield?
Nothing further, Your Honor, except I do think we need to discuss the concept of the special deeds trust internally among the attorneys, because I think what we've heard from Ms. Cole has been a misrepresentation of what Mr. Goodsell concluded when he said there seems to be no clearly correct option for Garrett, so hopefully we can work together to find one.
And as I look back, there was a special guardian ad litem appointed years ago, Ms. Boyer, who made a recommendation. I'd ask that the lawyers continue to talk about it. If you agree on everything else except for that, you can file another petition and we'll chat more about it. And then we have Ms. Cole's expert and, we'll have other information and I can make a decision at that point. This is an interesting financial case because he has large payments coming. I think in 2023 is the next payment. I would love for there to be a plan in place, an agreement about the investment strategy or the method in which that money is held well before 2023 so that it doesn't have to sit in an account and get very little interest. So that it can be utilized in a manner that takes advantage of everything that's available to him so he can use it all. Mr. Berchtold, anything else?
No, thank you, Your Honor.
So Mr. Berchtold, I rely on you to lead the conversation between counsel. I know the holidays are fast approaching, but I'd ask you to email and coordinate something within the next 30 days. And I understand that the holidays set everybody and travel schedule sets everyone a bit behind. But I'm going to take you to task on this, Mr. Berchtold, and make sure you stay in contact with everybody and chat with everybody. And if they're all not able to meet, perhaps meeting with individuals so that and certainly I'm not ordering you to meet in person, but to chat and get more information.
Certainly.
Anything else? Anything else from anyone else on the call today? Thank you so much. Mr. Black, did you want to say anything else today?
No, Your Honor. Thanks.
Thank you. Thank you all. Have a wonderful day. Ms. Cole, I'll look forward to about, I think by my estimation, 15 orders from you. So I know I've given you a big assignment, Ms. Cole, but we'll get those processed as you submit them to my law clerk's email. Thank you so much.